The people who work in this building right here are complete idiots. That's the U.S. Supreme Court.
Privacy violations are not adverse without a separate adverse action the privacy violation is used to create. Privacy violations are only adverse to the extent the privacy violation is used or can be used to create some other undesired consequence. But the Supreme Court said the adverse consequence is the privacy violation itself. In other words, the reason a random person is not allowed to see draft copies of Supreme Court opinions is because it will create a fleeting moment of pain, not because he will then use or disseminate the information with undesired consequences.
The U.S. Supreme Court think that the harm from a violation of your privacy ends when the person leaves your house or leaves your car or whatever.
The wrong condemned is the unjustified governmental invasion of these areas of an individual's life. That wrong is fully accomplished by the original search without probable cause. The use of fruits of a past unlawful search or seizure works no new Fourth Amendment wrong.
So in other words, if somebody breaks into your house and steals your account numbers, as soon as he's out of your house, the harm from that privacy violation is gone. Even when he's out there using your cards on the internet, or if somebody looks at your hand of poker, once he's seen the cards, the privacy violation is over. Even as the hand of poker goes on, now he knows what cards you're holding. But that's what the people in this building think.
The Supreme Court says the harm the Fourth Amendment protects you from is the cop breaking your door or being inside your car. If a cop searches your car without valid reasons to believe there is a crime, the harm to you ends the moment the cop leaves your car. They sell idiotic justifications like addicts. To say if a cop finds drugs in the illegal search, he can use that evidence in court. Because the harm the Fourth Amendment protects you from is already completed when the cop leaves your car or your home or whatever.
They think that the harm from a privacy violation is the harm from, your door being broken or having, an unpleasant person in your house. That's not what the harm from a privacy violation is. The harm from a privacy violation is people use the information obtained during a violation of your privacy to harm you and to take advantage of you. That is why privacy is important, not because other people being in your house is some terrible thing. No, it's cops using the fact that they're in your house to plant evidence, to lie about you, to take advantage of you, and the harm goes on long after they leave. That's why they violate your privacy. Cops don't violate your privacy because they like being in your house going, ha ha, we're in your house. No, they have a plan. When they search your house or your car without any real evidence of a crime that they can show a court, it's because they have a plan to harm you. They have an agenda. And violating your privacy is the first step in pursuing that illegal agenda.
These idiot judges misunderstand two things. One, the right to privacy. Two, distributed decision-making. The harm of a privacy violation is not that people are in your house or your computer. It's that they use the information or opportunity to harm you and take advantage of you. Someone who gets your account numbers can drain your accounts long after he has left. If they find out your schedule, they can use it to rob you. Police can find a really big knife in your house and a gun and some gloves and pick and choose in a way that looks suspicious. Police might have seen another person in your car. That's how they knew to search it. And intentionally leave that key detail out. They might find a design you drew of a new kind of meat oven and mistake it for a terrorist device and arrest you for terrorism. When police searched my friend's car, they mistook a floor plan from a rental for a burglary plan, and they staged evidence in her car. Distributed decision-making means whether you are guilty is supposed to be decided based on the evidence allowed. The evidence is not supposed to be allowed based on the judge already thinking you are guilty.
When you conduct an unreasonable search and seizure and find a bloody axe, do you have to let the axe murderer go? You let the criminal go. Even though you have him dead to rights and, he's a murderer or whatever, you got to let him go.
Police claiming to find incriminating evidence in someone's car is not proof that person committed a crime. And nor can judges decide it as proof and use that conclusion to decide whether to admit the evidence. Do judges know we have juries because judges are crooked? You can't say, oh, we know this guy is guilty. Showing this evidence will cause the jury to reach that same conclusion. Therefore, we should show it to them. Judges begin with the assumption you are guilty and cops don't lie. Some smug, arrogant judge who thinks this is proof of murder, this guy is guilty, does not understand why we have jury trials. And I can't explain it to him here. The judge is assuming the evidence wasn't planted, There's no way for the judge to ever know for certain whether the evidence was planted or not. And it is not the judge's job to decide whether the evidence was planted or whether the suspect is guilty. But because a judge thinks he is guilty, then we should go back in time and eliminate probable cause requirements. What if the evidence was faked? What if the suspect is innocent? The judge's job is not to decide if the evidence is fake or if he's guilty. The judge's job is to protect against cops just barging in and accusing you of stuff. The purpose of the Fourth Amendment is to stop the executive branch just attacking people by their own choice, not prescribed by law. What if most of the time the evidence was allowed in court, people were still found innocent? A judge would say, why are we going to let the government start this whole process of harassing innocent people based on some fake reason? Their ruling is based on the assumption that judges know people are guilty, and the purpose is for cops and judges to select what evidence the actual decision maker sees, to make sure they reach the right decision known in the abstract to third parties. People who were exonerated by DNA after spending 30 years in prison, usually the original probable cause was weak. Before cops started faking evidence and coercing jailhouse confession witnesses, their ruling is not materially different from the jailhouse confession witnesses lied. But so what? The defendant is guilty? He did what the liars said he did. If the idea is for the judge and cops to decide who is guilty, and then allow whatever is necessary to obtain the same decision from the actual decision maker, they should just be honest about it. When a cop searches you without valid reasons, he is singling you out for a reason not created by law. When a cop for some reason wanted to search a car when there was no real evidence of a crime, and immediately found drugs even though he had no good reason to believe they were there is an elevated chance he planted the drugs. Planted evidence is something the Fourth Amendment protects you from. Judges who have never been arrested can't imagine police lying and faking evidence. They don't know why we have juries, and they legislate based on their imagination. They talk all day about general problems no party had standing to bring in front of them, and facts nobody brought in front of them, such as what happens to other people who have been arrested, or what deterrent is necessary to protect other people from illegal searches. A judge who thinks the harm from a privacy violation is over when the violator stops looking should be forced to play out a hand of poker after his opponent has seen his cards, or to not cancel his credit card after it has been sold on the internet. Oh, come on, cops don't want to harm you like that.
He violated the Fourth Amendment, but he didn't realize he was and didn't intend to. So we let it in.